Hey guys, it's Group 6.
Section 23 and 24 of the CGA, together with the common law principles, have conferred Malaysian courts jurisdiction to hear the case. However, there are challenges in exercising such jurisdiction, where four aspects will be focused. The first aspect, service of notice of writ outside the jurisdiction. The first challenge is the rigorous examination of facts to satisfy the Hagen-Six principle. Due to the great emphasis on the need for the court to be cautious, it was crucially important that the court has considered all the relevant and material facts. Thus, not only that the court has to make sure there is full and fair disclosure as supported by Felda and Alrada, it is also mandated to apply for the forum convenient test, which will definitely incur a heavier burden on the court besides time and cost factor. The second challenge is the balance between discretion to grant leave and the reluctance to interfere with a foreign jurisdiction. As such service constitute interference with a foreign jurisdiction, the Malaysian court must have in its mind the balance between Committee of Nations and the plaintiff interest, which essentially leads to complexity in an attempt to balance between the two.
Moving on to the topic of forum non-convenience, the application of the second limb of the Spidada doctrine resulted in the overly broad and vague judicial discretion as to constitute an instinctive process. As shown in the Australia case of Oceanic Sunline, English law had moved from a confined discretion under Sanfier to a broad discretion. Hence, this leads to unpredictable outcomes in whose favour the Spidada test is likely to be applied. This is illustrated in the two cases of Pacific International and Ultima Holdings. Where issues in respective cases were not wildly different from one another, it unfortunately did not reach the reasonable anticipation of coming to the same results. While Pacific International dismissed the claimant's assertion that there exists unfair hearing in the most closely connected forum, Privy Council in the Ultima Holdings ruled such assertion was one of the main contributing factors that England was forum convenience. As such, this state of affairs can hardly be desirable. This is substantiated by D.W. Robertson article on forum non-convenience. Hence, Malaysian courts in following the English position on foreign non-convenience lack specific guidelines to assist determination, rendering unpredictability in each case. Also, as the application of Spidada test is fact-specific, almost any factor can be taken into consideration, resulting in overloading of examination of facts. This results in voluminous evidence and hence further complicates and lengthens the determination on the most appropriate forum. In OJSC Oil Company, nearly half of an 8-day trial period is used to decide whether the Russian court could justify disposing of the parties' dispute. Whereas in Pacific International, the whole of a 2-day hearing and approximately 1,500 pages of the bundle were devoted for the discussion of the second limb of Spidada test. Hence, allocation of time and resources by Malaysian courts toward disputes which are of little connection is uneconomical and frivolous.
Moving on to foreign jurisdiction cross-topic. The first challenge here would be the existence of uncertainty as a result of court discretion in applying different tests. There were 5 factors listed down under the Avatar case to determine the impossibility of foreign jurisdiction clause. However, a cross-analysis shows that the judges have, in substance, decided them on the basis of foreign non-convenience, because the judges usually concentrated on factor A to C only, which basically deal with where the trial should most appropriately be held. We must remember that the foreign non-convenience and the exclusive jurisdiction clause approaches are different. Hence, despite there being a straightforward application of the Avatar approach, the judges were in fact deciding the factors on different weights, which essentially creates uncertainty for the court in making the decision. Moving on to the second challenge, the balance between the need to enforce foreign jurisdiction clause and the existence of local connection that weren't present in Malaysian courts. If there's rarely refusal to enforce foreign jurisdiction clause, it will encourage foreign shopping. On the flip side, if the Malaysian court adheres strictly with its obligation to enforce the clause, it may result in a case being heard in the foreign courts, which is not a foreign convenience. Hence, there's a challenge for the court to balance the use of foreign jurisdiction clause. The third challenge, ascertainment of what constitutes strong reason to not grant a stay. As in Ward Triaton case, the court held that more is required to constitute a strong reason, and practical inconvenience is not a determinative factor. What matters most is the suitability of the foreign which will meet the end of justice. Thus, the factors in Spidada do not amount to strong reason. The Malaysian court have to determine such on a case-by-case basis, where sometimes policy reason may further insert complexity.
Last but not least, issues of Antisodine Junction. The first challenge is the higher threshold due to additional elements of injustice. As laid out in liquid drugs, the additional element of injustice and not mere inconvenience has indicated an even higher threshold beyond the Spiliadus test. Hence, a more stringent test needs to be passed, including considerations of comity, resulting in our court's reluctance to protect integrity of own processes. Next, ends of justice demand granting of Antisodine injunctions, but it is vexatious or oppressive, which leads to this second challenge on its meaning. Despite Sabah Shipyard expressed that such determinations depends on the peculiar facts, this would mean that all circumstances are relevant, including factors stated here which would definitely incur times and cost factors. Next, the requirements that party must be amenable to local jurisdictions also raise challenges. This requirement does not raise difficulties if the party is a Malaysian resident, however, it will be a challenge if he is a foreign resident, creating complexity on whether the Malaysian courts has the jurisdictions to do so. In conclusion, jurisdiction is the underlying hurdles to be satisfied before any legal proceedings, and hence such challenges must be crossed accordingly. And thank you for listening.